Hello, Assalamualaikum and good afternoon, students.
Afternoon,
Hello.
madam.
Good afternoon, madam.
Okay, good afternoon. Okay, we are coming nearly to the end of the course. Okay, um, so for today's topic, you will be exposed to the occupational safety and health at workplace. Okay, so it's like we have like combination of OSHA itself. Okay, OSHA, and then what do you call sexual harassment in the Sexual Harassment in the Employment Act, okay, and then SOCSO, okay, a bit on workmen compensation, and the last one will be on the EPF. Okay, so I just edit the slides today. Okay, so I'll be I'm not sure whether it's can you access to the notes or not
No,
yet?
madam. I cannot
Not
find
yet.
this now.
Okay, maybe I have not what do you call previously it was hidden, so when I edit, I'm not sure whether I already replaced the new one, or is it still uh, I mean it's not accessible to the student yet, okay, but I think from the lecture you can also access without the notes. Sure. Okay. Can you access if I have not upload, but you can hear from my lecture today? Is it okay?
Yes, it's okay.
Okay, madam.
Okay. So we will give you one assignment on topic 13 to 14. Okay, so that will be the third assignment. Okay, so but not all the what you call aspects will be tested for the assignment. Okay, because it's like involving about 5 different legislation. Okay, so we will look at OSHA first. Okay, so OSHA is we have previously we have the Factory and Machinery Act. So this act superimposed on the existing safety and health legislation, mainly Factory and Machinery Act. Okay, so Factory and Machinery Act still applies to factories, okay, where they have the machines or they have the plant. That means the machines that need certificate. Okay, you know that if you want to do production, you need to have certain kind of machine. Okay, so the machine need certificate of fitness. That means is safe to be used. Okay, but we will look at OSHA, where OSHA covers about 10 industry. Okay, so I just want to inform you that we have another act, that's Factory and Machinery Act. Okay, so OSHA provides the legislative framework to secure the safety, health, and welfare among all Malaysian workforce, and also to protect others against risk to safety or health in connection with the activities of persons at work. Okay, so that's the aim, okay, of the act. That means it will be for the safety, health, and also welfare of all the workmen in Malaysia. Okay, and also to protect others who are involved at the workplace. That means people like contractors, visitors, okay, manufacturers, designer, okay, whoever is connected to the workforce, they are also protected under OSHA. Okay, so this act is gazetted in 24th February 1994. Okay, so the aim of the Act OSHA is to secure safety, health, and welfare of persons at work against the risk to safety or health. Okay, this is against, I mean, to protect all the persons who are exposed to risk to safety and health. Okay, Then to protect person at the place of work other than person at work against risk to safety or health. This other person means who are not working actually, but they are at the workplace. Okay, like contractors, suppliers, okay, visitors, okay, they must be protected also. Okay, then to promote an occupational environment for persons at work. Okay, that means to give a better working environment to all people who are at work. OSHA also, okay, are based on self-regulation scheme. It means that, okay, the responsibility to ensure safety and health of work lies with those who create the risk. Okay, that means every person who create the risk. Okay, and those who work with the risk. That means if you are a contractor, if you want to supply any what you call material to the let's say construction site, you also must take steps. Okay, precaution to maintain safety and health at the workplace. Okay, visitors also, okay, if they want to visit, they must make sure that they wear proper what you call equipments. Okay, when they want to enter, let's say, construction site, they must wear helmet, they must wear proper shoes. Okay, so the responsibility to ensure safety and health is on all the persons who create the risk and also who work with the risk. Okay, so this is the self-regulation act. That means everyone have to play the role. It's not the employer's duty anymore for safety. So the responsibility is on the employer, employee, manufacturer, designer, everyone. Okay. So the concept of self-regulation encourages cooperation, consultation, and participation of all the employees and also the management. Okay, in effort to upgrade the standards of safety and health at the workplace. Okay, so certain machine, okay, a person who manufacture the machine or who supplies the machine, okay, who fix the machine also has the responsibility. So it's a self-regulation act. That means everyone have to play the roles, starting from the employer, employee, visitor, even the person who own the building, that's the proprietor, okay, a manufacturer, a designer. Okay, so everyone have the role to play for safety and health at workplace. Okay, so OSHA applies to many industry like manufacturing, mining, quarrying, construction, agriculture, forestry, fishing, then utilities, gas, water, electricity, and etc. You can see almost all the industry in Malaysia, okay, have to apply OSHA at work. Okay, OSHA is the Act, Occupational Safety and Health, 1994 at the workplace. Like even hotel, restaurant, finance and insurance, retail, estate, business services, okay, or public services and also statutory bodies like UUM, public university, statutory authorities like we have the what do you call local board like town council. Okay, they also have to apply OSHA. Okay, so that's the application of OSHA. Okay. Okay, so do you have any question on OSHA so far?
So far, I don't have.
Okay,
madam.
okay, thank you. So you must know OSHA applies to which industry, who has the responsibility. Okay, so now we look the parties are involved to create a place that is very safe for the employee at workplaces. Safe, that means safe and also healthy and also that consider about the welfare of all the employees. Okay, so we start with section 15 here. Section 15 mentioned about the general duties of employer, okay, and self-employed person. Okay, self-employed means you are the employer and you are the employee. You are self-employed. Okay, employer is the person who employs the others to work with him. I think you can still remember the general definition under the Industrial Relation Act and also Employment Act. Okay, so we'll look at what are the duties towards their own employee. Here is their employee. Okay, so Section 15 says that so far as it is practicable, that means you do it to the extent of practicable, okay, the safety, health, and welfare at work for all his person, okay. So this is the general duty, okay. So here is mentioned in detail what are the employer and self-employed person must do so far as it is practicable in terms of safety, health, and welfare of all his employee. Okay, first is in relation to the provision and maintenance of plan and system of work. Okay, so the employer and the self-employed person must make sure the maintenance of plant. I think plant you must. Do you know what is plant? It's not.
It's like some sort of industry factory. Yeah, factory.
Yeah, it's like a big factory where they have the big equipment to produce or to process something. And sometimes you can see like it is outside the building also. It's so big that they have to put outside the building, and sometimes it's a bit small where they can put in the factory, like any kind of machine, okay, where they're going to produce their products. Okay, so anything to do with maybe like to for the safety, that means the equipment that you're going to fix, let's say for the cold storage room, or maybe for the electricity, okay, or maybe to process the any products, okay. So all those are the plants, okay. And the system of work, okay, in the particular place, okay, must be safe and without risk to health. Okay, so the first one is regarding the equipment at the workplace, the plant, and also the system of work. That means the process, how to do certain work. The SOP. If you want to switch on the machine, what you have to do first. Okay, maybe you have to wear some self equipment first. That means some protective equipment first before you can switch on the plug. Okay, then maybe you have to wait certain minutes so that you can on another machine, and then after that you have to maybe on another machine, okay, and then you must make sure that the machine must be fixed some guard or maybe some fans, okay, before it is generated. Okay, so that's about maintenance of plant and system of work. Okay, then B is about safe operation. So when you want to operate the plant, okay, it must be safe, okay, and then you want to handle, or you want to storage, or you want to transport the plant and the substance. Substance means it can be in form of any liquid, or maybe any materials that you're going to use. It can be like a liquid, or it can be in form of maybe powder or anything. Okay, so the definition for plant substance are all in OSHA. You can look in detail. Okay. Then the provision of such information. Okay, so you want to give information to your employee. Okay, you must make sure that you give a proper information, instruction, together with training, then supervision, okay, which is necessary to ensure the safety and health of his employee. That means the employer and the self-employed person have to give enough information. Okay, that means you have to uh, really guide them how to run or to operate the machine, give instruction, give training, give supervision. That means if they are new employee, you must make sure that you give them training, okay, how to operate or run the machine. Okay, this is all to ensure the safety and health of his employees. Then the maintenance of the place of work, including the means of access and also to address. That means the way to the building. Okay, the entrance is the access place. and the egress is the way out. So you must make sure that you maintain also the place to the machine. Sometimes the machine have to be placed downstairs, okay, and you have some stairs to go down, okay, so you must make sure that it's all safe, the place to access to the machine and also to way out from the place where the employees are working. Okay, so you will see that when you go to even UM, okay, the building there, okay, for the lecture, you want to enter to the lecture hall, okay, is stated there, okay, where you have to in and also out. Oh, that's the place where you're going to access to the building and going to come out from the building. Okay, when you go to cinema, you can see sometimes is there's light there so that you know where to go in, where to come out. Okay, so it must be maintained. Okay, sometimes you have to fix some lights or you have to put a door. Okay, and the door sometimes must be fireproof door. Okay, or it must be made from some kind of metal. Okay, so it's how you're going to maintain it. It all depends on what industry you are focusing. Yeah? Okay, then safety and working environment and facilities for their welfare at work. Okay, so this environment means, what do you think can be working environment, students?
Maybe the ergonomy.
Okay, the way that you are given like proper chair. Sometimes if you're working in a bank, okay, you are cashier, you must be given a proper chair, ergonomic chair. That means the chair that can support you to sit for long hours. Okay, then what else, students? What else you think you need if you're working? Okay, you want a good working environment and facilities for the welfare of you. Aircon, temperature, yeah. This is saying about working area. Okay, so now COVID, during COVID, working area is very important. The temperature, that means it must not be so cold or maybe not warm. You want a medium temperature at the workplace. Okay, maybe you want a room to rest. Okay, or maybe lunch, you want a room where you can take lunch at workplace. Okay, so those are the working environment, and some industry need employer to give place to what do you call, place to stay. They got their quarters. Okay, where electricity and also water must be supplied. Okay, so those are the general duty of employer and also self-employed person. Okay, Fidaus is saying about appropriate height of working space, not too short or too high. Okay, yeah. Some industry they really give very limited space for you to move, and then even you cannot sit after sitting you cannot stand up, okay, or you have to like bow your head so that does not hit the above equipment. Okay, so it depends. Sometimes you have the working experience. Okay, so you will know that how your working area is very important. Okay, so it's under section 15. So our OSHA actually is from the UK OSHA Act 1974, I think. After 20 years, we have our own law on OSHA. So you can compare some of the provision. It's about similar provision. Okay, and some might not be the same where the amendment. Okay, already finished this. Okay, now further duty of employer. Okay, the duty to formulate safety and health policy. Okay. Okay, so employer also have duty to have one policy on safety and health at workplace. Okay, where every employer who have more than 5 employees must draft and disseminate to his employees a written safety policy. I think if you go or you have some working experience, it is put sometimes at the entrance or maybe in the office. This our policy, safety policy. Okay, so you can Google and look for one. It's just like one piece of paper. It's not more than one. Okay, they put their policy at the workplace where it is like put into a frame and in a big size of paper. Okay, so that every employee can have a look and also understand what is the company's safety and health policy. Okay, so the here the policy, okay, must be bring to the attention of the employees and also must be revised. Okay, must be revised. That means you cannot have the same safety policy for 10 years. Okay, you must prepare because it's very general. Okay, and it must be up to date. So you it's stated under section 16. Okay, that you must bring the statement and any revision to the employees notice. Okay, then section 17. Section 17 is the duties of employer and employee. The duties of employers and also self-employed person to other person than their employees. Okay, so here what is different is other person. Okay, not to their employees anymore. This is other person. Okay, so it's also stated here that the employer, okay, must make sure that they do not expose, okay, other person who are not being their employee, okay, to the risk to their safety and health. Okay, so other person here at the workplace is like who? Can you name other person that who will be going to workplace beside employees?
Madam, can you repeat?
Here, this section says that the employers and also self-employed person have duty, okay, to other person, okay, than their own employees. Okay, so who are the other person here?
Can the shareholders consider one
No, they must be at the workplace.
or workplace?
Mhm. Shareholder, they might come but not very often, but you can say but their percentage of being there is not high. Okay,
Maybe officer.
Officers, you mean officer from where?
Like maybe they want to conduct an inspection. That kind of officers.
Officers, especially construction site, you got officers from maybe from the safety department coming. I saw one who wrote here, where's the chat? Client, okay. Nuru says client, yeah. Can be the client or customers coming to the bank. Okay, you know, bank, they got customers coming to the bank, so the bank must make sure that it's safe for the other person than the employees. Okay, then has who is that? You got any question? Has Ricky Jody? No, I thought you raised your hand. No, okay. So it can be suppliers, okay, who come there, visitors. Sometimes you got some people coming to visit your site, like you know, some during those days when I was school children, we go for day trip to factories to see how certain factory process products. Okay, so I can still remember I have been to a mosquitoes coil factory to see how mosquito coils produce. A biscuit factory, how they produce biscuits. Okay, so the employer have duty, yeah, okay, to make sure the place is safe for those visitors also, visitors, clients, any persons coming to the workplace, okay, other than their own employee. Okay, so that's under section 17. Okay, then section 18 says that duties of occupier of a place of work to person other than his employees. Okay, in Malaysia normally we have the owner of the building. So occupier is the person who occupies the place. Okay, sometimes it can be a different person. That means owner of the building and the occupier is a different. Okay, so he also have the duty, okay, to make sure his building is safe for the other employees. Sometimes you rent a building, you must make sure that it's safe, okay, to persons who going to run the business. Okay, so section 19 is about the penalty for section 15, 16, 17, and 18. Okay, so now we look at the general duties of the manufacturer. Okay, so the manufacturer, the person who manufacture any plant, okay, so he must also make sure that it's safe at work. Okay, so it's safe for the use at work. Okay, then the substance, section 21 is about the substance, because the wording in section 20 and also 21 is about the same, only the difference is that one refer to plant and the other one is about substance. Okay, so I think you can read section 20 and 21 where there's an explanation in section 22 and the penalty is stated in section 23. Okay, you must not breach your duty under section 20 and 21. Okay, because it will be an offence under OSHA. Okay, so that's the general duty of manufacturer towards plants and also substance. Okay, so now section 24. Section 24 is the duties of employees. Okay, all the employees, they have the duties. So we look at the duties here. First is that they must take reasonable care for safety and health of himself, okay, of himself and also other person who may be affected by his act or omission at work. Okay, so employees, if they are given certain personal protective equipment, let's say boots or maybe what do you call sometimes helmet at the construction site you can see, okay, they must make sure that okay they wear, because they must take their they must take care themselves, they must take reasonable care for safety and also health of themselves and also other person. Okay, so it's both, okay. Then the employees must also cooperate with their employer or any other person in discharge of their duty. Okay, so they must make sure that they follow all the instruction given by the employer or maybe other person, maybe the manufacturer or designer say that, oh, this is the instruction before you want to use the product, so you must follow the instruction. Okay, then employees also must wear and use all times any protective equipment or clothing provided by the employer for the purpose of preventing risks to his safety and health. Okay, that nowadays you got COVID, you have to use sanitizer, you have to use the mask. Okay, you must follow the instruction to use personal protective equipment including clothing. Clothing is sometimes you are given special apron, sometimes it's like jacket made of plastic you have to wear before you enter certain premise. So you have to follow the instruction of the employer. That's the duty of every employee. Okay. Then D is to comply with any instruction or measures on occupational safety and health instituted by his employer or any other person. Okay, if there's any measure or instruction regarding safety and health, okay, by the employer or any other person, the employee must also comply. Okay, so these are the duties of the employee under section 20. Okay, so section 25 says that employee also have a duty not to interfere with or misuse things provided pursuant to certain provision. Okay, so this is not the employee, actually the employer. Okay, do not interfere with or misuse things. Okay, it can be both parties actually. Okay, so you must make sure that you do not interfere or misuse anything that provided. Okay, under the maybe under the law, or maybe by the employer. Okay, then the employer also have the duty not to charge the employee for things done or provided in the interest of safety, health and welfare. That means if you supply helmet, or maybe a boot, okay, or maybe mask or sanitizer, the employer cannot charge the employee on this. Okay, can you understand?
Yes, madam.
Okay. Then section 27 says that the employer cannot dismiss an employee or injure the employee or alter his position, okay, by the reason that the employee make complaint about a matter that related to safety and health at workplace. Okay, so if the employee complains, in the social media, sometimes you can see employee, sometimes there is trade, okay, where safety officer come and make inspection, okay, at the workplace. Okay, so if the employee complains to any authority, the employer cannot dismiss, injure, or alter the position of an employee. Okay, then it can be on the employee himself, or if he's a member of a safety and health committee established under OSHA, okay, or exercise any of his function as a member, or a member of the safety and health committee. Okay, so if the employee do anything to do with his duty, okay, the employer also cannot discriminate. That means discriminate can be in many ways, okay, as like to dismiss, to injure, or to alter his position to his detriment. That means to the disadvantage of the employee. Okay, so this is under section 27. We got A, B, and C. Okay, then appointment of safety and health officer. Okay, so you know that certain industry have a safety and health officer. Okay, so not all industry, so it's as decided by the Minister of Human Resource. Only certain industry need safety and health officer. Okay, so the appointment is as stated in the OSHA itself. Okay, so under section 29, so that there's a list where you can refer which industry needs safety and health officer. Okay, then section 29 also says that the duty of the safety and health officer is to advise the employer on the steps to be taken to ensure the safety and health of the employees at the place of work. Okay, so what are the duties of the safety and health officer? Is stated under section 29. Okay, then he also have to inspect the place of the work to detect any potential hazard. Okay, like construction industry, they have safety and health officer. So the officer have duty to do Okay, he must inspect the place of work in case there's any potential hazard, and he also must assist the safety and health committee to carry out the functions. Okay, so that's the duty of safety and health officer. Okay, then certain place of work, okay, need safety and health committee. Committee, okay, is the previous session is about officer. We only need one or maybe few officer at the industry, okay, but committee is different. Okay, this is under section 30, where every employer who employs 40 or more persons must establish a safety and health committee. That means if your company have more than 40 employees, you must have a safety committee. That means factory with more than 40 employee, or maybe uh, university that have more than 40 employee, or bank that have more than 40 employee. Okay, you must have one committee. The committee is like your own committee at the workplace. Okay, so the committee shall have chairman, okay, secretary, and also members. So they have to do everything to do with the safety and health at their own company or factory. Okay. Then the function of safety and health committee is also mentioned in OSHA, okay, in section 31. There's assisting in development of safety rules and system of work. That means this committee must come up with safety rules. Okay, what is the safety rule at workplace? Then must review the effectiveness of the existing safety and health programs. Okay, then conducting studies on accident and disease trend in the maybe factory or construction site, depending where uh, where the committee was established. Then making recommendation as to how to improve unsafe and unhealthy situation at the workplace, then to review the safety and health policy. Okay, so if you do not know what are the safety and health committee supposed to do, okay, so it's all explained in detail in section 31 of OSHA. Okay, then the in case okay, there's any accident at the workplace, okay, section 32 says that the employer are required by OSHA to inform the nearest DOSH office in the event of accident, dangerous occurrence, occupational poisoning, and also disease. Do you know what is DOSH?
Department of Safety and Health.
Yeah, it's just the department, like you got the industrial relation department or labor, what do you call, labor office. So the department that relate to OSH is DOSH. DOSH is the Department of Occupational Safety and Health. Okay, so in case there's an accident, maybe in construction site, or maybe at the factory, or maybe there's a dangerous occurrence or poisoning, even disease, you have to, the employer have to inform the nearest DOSH department, DOSH office. Okay. Then the employer also must report to the DOSH fatal and also any accident causing to a person whereby he's unable to work for more than 4 days. Okay, so fatal means death. In case of death and accident, where accident make a person unable to work more than 4 days, the employer must also report. In case, let's say, the employee fall from the building, or he hurt, or maybe his hand caught by the machine. Okay, anything to do with accident at the workplace, the employer have the duty to report to DOSH. Okay, and then the doctor who attend the patient also must inform or make report to DOSH. Okay, so in case you see there's a maybe accident, okay, which make employee's hand injured or maybe amputated. Okay, so the doctor who give medicine and treatment to the employee also have a duty to report the matter to DOSH. Okay, so it's all related. Okay, not the employer, so that maybe the employer can hide any incident, but the doctors have to report. Okay, so I think that's all on OSHA. Okay, any question that you want to ask me?
So far, no.
Okay, so I try to continue another topic today because the next Thursday I want to give off for you, okay, so that you will what you call look over again your assignment too before you submit, okay, and also you can search the case that I will be mentioning in next topic. Okay. Wait, can't eat because it's not. Psychological disease like severe mental health issue is caused or overwork. Okay. Here, the section, this section says that the employer is the one who have to report. Wait, Section 32 says that it's about accident, dangerous occurrence, poisoning, disease. Okay, so a psychological is not a disease. It's like illness. Okay, this illness the employer cannot report because it's not covered under OSHA. Okay, OSHA does not cover psychological problem or illness. Okay, and we don't have any law to protect the employees from psychological illness or problem in Malaysia. Okay, but you can take legal action, okay, against your employer if you got enough proof, because it's very difficult to prove our mental illness, because it must be really related to work. It's not like you got family background or maybe some other reason. Okay, so in Malaysia we do not have, okay, and actually there's one research, our School of Law doing on psychological illness, okay, to introduce a law on this matter. Okay, so I will continue with okay, so any objection on class on this Thursday? Any objection that I want you all to do your assignment, review your assignment again before you send, and also to read the case on today's topic? Any objection? You still want your class on this Thursday, or is it okay that you want to use the time to look over on your assignment too? Okay, so is it okay? I see here no problem, no madam. Okay, so OSHA, okay, talk about safety and health at workplace. So sexual harassment is also regarding safety of employees. It can be towards the female employee especially, and men or male employees. Okay, because we got cases going to the court where there's a sexual harassment against male workers. Okay, so in Malaysia, okay, we do not have a specific law on sexual harassment, but we got a code of practice on the prevention and eradication of sexual harassment in workplace. This code was introduced in 1999, okay, where there's a outline on statement for the purpose why this code was introduced, the legal definition of harassment, the prescription of behavior that constitute harassment, how employee should handle harassment, and how the company handle complaint, and the kinds of disciplinary action. So if you are working at the HR department, you should know the contents, even though we do not have the law, but it's a very useful guide, guideline for the HR officer or maybe supervisors, how to handle sexual harassment at the workplace. Okay, so in case of sexual harassment at workplace, we have amendment in the Employment Act 1955 that's under section 81A to G, because it's a new provision, you cannot add in sections. So a new section has been made, but we have to use alphabet to show that there's a new provisions, A to G. Okay. So this section is about sexual harassment complaint. Okay. In relation of employer and employee. So it can be by an employee against another employee. It can be by the employee against his own employer, or by an employer against his employee. It can be anyhow, okay, because sometimes employer also can be harassed by his own employee. Okay, so section 81 applies. Okay, so under section 2 of the Employment Act, sexual harassment is unwanted conduct of sexual nature, whether verbal, okay, non-verbal, that means if you use some verbal words, or it can be non-verbal, okay, where it is in form of showing some photographs, okay, visual, okay, gestural, or physical. Physical is where you touch and have direct contact with the person, okay. So it is offensive or humiliating, or it is to treat to his well-being, rising out of and also in the course of employment. That means the sexual harassment is happening in the course of the employment. Okay, it's between the employer and also the employee or any other person at the workplace. That means it can be by the colleague, the other workers, okay, co-workers at the workplace. Okay. Okay, so the Employment Act imposes an obligation on the employer to inquire into any sexual harassment complaint in that section 2. Okay, so any person dissatisfied with the refusal of the matter by the employer can refer to the Director General of Labour. Okay, so if there's any sexual harassment at the workplace, first you must complain to your own employer. Okay, unless he refuses, then you must report. If you want to go further, you report to the Director General of Labour. Okay, so if the employee is satisfied the sexual harassment is proven, because he must take his own action. Okay, the employer have to conduct hearing, gather information, and take disciplinary action against the harasser. That means the wrongdoer. Okay, so he can take action like in section 14 of the Employment Act, dismiss him or downgrade him or do any other punishment, take any other punishment that he thinks fit, okay, as a punishment for sexual harassment. Okay, so where the inquiry is undertaken by the Director General and the Director General satisfied that sexual harassment has been proven, the complainant may terminate employment without having to comply with the termination notice. Okay, so here, if there's actually sexual harassment, okay, the complainant, that means the victim, can terminate the employment without giving notice to the employer. Okay. Okay, so if the employer failed to comply the provision under section 81 just now, okay, is an offence where it can be fined not exceeding 10,000. Okay, and the employer also liable if he failed to conduct an inquiry when there's a complaint of sexual harassment, or if the complainant to inform the complainant why he refuses to carry or to conduct an inquiry. Sometimes you complain to the employer, but the employer just keep quiet. Okay, so it's actually an offence. Okay, then he fails to conduct any inquiry when directed to do so by the Director General, or maybe sometime in case where the employer failed to submit a report of inquiry when directed to do so by the Director General of Labour. Okay, so this is all under Section 81, where the employer have a duty to do certain act when there's a complaint of sexual harassment. Okay, so if you the other thing that the employer can do is that he can also not he actually the victim can report to the police, and it is a offence under section 501 of the penal code. So sexual harassment is also a criminal offence. Okay, so if the employee goes to the police and report, okay, so it is what you call criminal offence under our Malaysian penal code. Okay, and there's one new case that you can read. Okay, Muhammad Ridwan Abdul Razak versus Asma Haji Muhammad Noor. Okay, 2016, where the court reward to the victim compensation because of the sexual harassment by an employee. Okay, so do you have any question on sexual harassment?
Understood, madam.
Okay, so I see students leaving. Do not leave until I finish the class. Okay, 47 students only. Okay. Okay. So what you have to do is for the next class. Okay. On Thursday. Okay. So before you submit your assignment too, okay, I want you all to check certain things from the assignment, okay, because I have gone through assignment 1, okay. I just go through the by looking at the format, okay. Some of the assignment 1, okay, is poorly written. Okay, I'm not sure why. The issue is very short. Okay, and there's one that I saw no case at all. Okay, and another assignment, no Malaysian case has been referred. I think the student got a case from India. Okay, so make sure that when there's a proper session, you use what you call the section, okay, section like assignment 1, I see section 14, okay. So there's section, but the student did not quote the section at all, okay. Like no provision from the Employment Act 1955. I'm not sure what the members of the group do. Okay, even though you divide the work, assignment one, let's say you divide 4 or 5 of your friends are doing. Okay, after you got the answer, make sure that you give the other members to read the answer, because if you do it yourself and you do not work properly, maybe one person do assignment, find the issue and case, and the other one do application, the other one do conclusion, and then you just combine and you send without reading. I think at the end you will enjoy the same marks. It's a poor mark, then you will enjoy the poor mark. Okay, because see one aside, I think two not satisfied at all, because no case. Okay, no section, even the section 14, the other, I think the I think open 6, okay, 6 project paper that I already seen. Okay, um 2 is not properly written, very poor. Okay, no case has been written, no section has been stated. Okay, and then like you got 2 issue but you just answer in 1 paragraph, although there's only 1 issue. Okay, um so you must make sure that you read what your friends or the member of the friends already prepared. Don't simply send, even though you know that you already divide the work among yourself. You say, okay, I already finished my work. Okay, now is other members' work. Okay, no, you have to go through and see whether your friends have properly written the answer or not. Okay, and then do not put all the answer in 1 paragraph. You know how long the paragraph is? Nearly 3/4 of the page. It's only 1 paragraph. You put everything in 1 paragraph. You know, if you use highlight, it's supposed to have like issue. Okay, then you have the what you call law application. Okay, do not put everything in 1 paragraph. And then if it is a direct question, it's also the same. Do not put everything in 1 paragraph. You must know that. Okay, you have already also mentioned previously, direct question, you have the introduction, you have the body. Body is the answer. Then you make the conclusion. Okay, that's all, not much. Okay, if you ask to compare, then you make comparison. Okay, so in the body, if there's any case, if possible, you can also underline the name of the case. Okay, or you can also highlight the name of the case, or you bold the name of the case, and also the provision, so that it looks very neat. Okay, because I saw one assignment is so long and the name of a case is not like highlighted or bold. I have to search where is the name of the case, because everything is in 1 paragraph. Okay, so make sure that you know how to answer. Okay, I'm not sure because you're all like mixed up, semester 2, semester 5 and the others, because if you're already semester 5, you're coming to the end of your course, your studies, so you must able to prepare a good maybe project paper or maybe a report when you are asked to prepare, maybe by your employer or maybe your management. Okay, so uh, then your name in the assignment, okay, your name actually uh, uh, I do not know why you want to put your metric number, okay, not in order. You know, numbering 1, 2, 3, 4. Okay, even the metric number in the your attendance is in order. So in assignment, when you want to send assignment, you must make sure, okay, your members, the name of the members, when you put the name of the members, the metric number must be in order. Okay, so that's the thing that I'm not sure other lecturers let you all know. No, it's very important. Okay, that you put the metric number in order. Okay. Okay, so if for the assignment 2, make sure that you check your answer again. Okay, then you highlight the name of the case, okay, or you bold the name of the case, I think it's okay, bold or underline, okay. Then you must make sure that you have provisions, okay. And I saw one student referring to Employment Act 1996, okay. I'm not sure which group, Employment Act, UK 1996. You're supposed to use our Malaysian provision when you are answering to our, your assignment, because there's the question straight away referring to the Employment Act 1955. Okay. So if your answer is wrong, I cannot do anything. Okay. Then I saw issue which is very short, like whether Ahmad dismissal is unfair. Dismissal. Why is it very short? And it is not specific. You know, in the facts it's already explained. Okay, he's not been paid wages, or he have not not been given work for 3 weeks. Okay, it's already explained. So why is it very short that you want to because when you read the issue, okay, you will expect the examiner, okay, to know the answer. Okay, like the first question, okay, whether the employer provide a safe working environment, or whether the employment, I forgot the case, the question, the what do you call, the mid exam, okay, um, whether he's supposed to provide a safe working environment, whether he's responsible to provide a resume. Okay, so from the issue, okay, the examiner can predict the answer. Okay, so I think for the group, I don't want to mention the group because I want you all to do better in your assignment too. Okay, understood, students.
Yes, madam.
Okay, so who is asking? Is it compulsory to put case in every issue? Depends. Okay, you know that when we study also, not every statement that I give you all have cases and also provision. Sometimes they are both. Sometimes there is no case but there's only section. Sometimes there's only section but no case. So it depends how which topic has been tested. Okay, so um and if you put more issues, sometimes the answer will be repeating also. Okay, so you must know whether it's 2 issue or maybe it's a 3 issue. Okay, or maybe it's 1 issue. Like your mid exam question, I think many of you all just answered 1 issue on safety aspect, but the issue is on safety and then not providing work, and then the other one is on providing resume. Okay, there's 3 issue. Okay, it's 20, it's like 14 marks, I think. So there's 3 issue in the particular question, mid examination. But many, not many, maybe about 30% or maybe 40% answered 3 issue, then the rest put 2 issue, and then there's also mentioned only 1 issue. Okay, and there are also students who put 3 issue but only answered 1 issue. I don't know why. Okay, and also for the mid-exam students referred to the English law, okay, where you're supposed to answer using our Malaysian law, because it depends on the topic. We learn English law when there's only necessary, okay, lacuna. Okay, you can use the English law. If not, you have to use the provision from the Employment Act, Industrial Relation Act, maybe OSHA or maybe EPF, okay, Trade Union Act. Okay. Okay, students. Any other question that you want to ask me? Okay, so I hope that you will do better for your assignment 2, because assignment 3 you got 4 questions and you got 1 week to do. So I think most probably I will give you time to prepare your assignment 3. Okay, and we got one more topic. I mean, maybe we can finish within 1 or 2 lecture. Okay, the other topic on SOCSO EPF. Okay. Any question?
No, madam.
Okay, so thank you. So I will stop here. Okay. So please prepare. So for this Thursday, okay, make sure you prepare your take your time to prepare the assignment. Okay, read the answer again. Okay, you can ask your friends, the members to edit. Okay, and you can search for a case. Okay, on sexual harassment. Okay. And you can also refer to the Employment Act on sexual harassment. Okay. Okay. So thank you very much. So anyone that still need attendance, because sometimes I see that you do not take I mean scan for the attendance and you quickly leave. Okay. After a few minutes listening. Okay. So I just put your the attendance here for others to scan. Okay, so thank you very much. Okay.
Thank you, madam.
Okay, welcome.
Thank you, madam.
Madam.